Good afternoon, everyone. Thank you for joining us for another C3 Workplace webinar. Happy to be here with you in between our snowstorms. I am joined here today by Eugene Kublanovsky.
Hello.
And we're going to be talking to you about how to protect the value of what might be one of your greatest assets, which is your brand. But before we get started with the webinar, we'll spend about 30 minutes today talking about this. Eugene will do a great job of kind of giving you an overview, and we'll give you some important information. A little bit of housekeeping. You are being recorded, and you will call in for the audio. You've already done that. You're muted. So if you have questions, there is a chat window. So feel free to put your questions into the chat window, and we will do our best to get to those questions. The 30 minutes tends to go kind of fast, so we'll do the best we can. And also, just to back up a minute, most of you know, but in case you don't, I am the president and founder of C3 Workplace. We have business centers in Montclair, New Jersey, and Sparta, New Jersey, and we provide safe support and education to help businesses start and grow. This webinar is certainly part of our educational program, and the C3 stands for Connect, Collaborate, Community. It's our vision that by bringing businesses together and helping them to grow, we will be successful, they will be successful, and that success builds into our communities. And it's a pretty fantastic thing, and I'm really one of those incredibly fortunate people who love what I do. So this educational piece is really important to us, and we are thrilled to have Eugene here, who has been practicing law for quite some time. After working in a New York City law firm for 10 years, he moved over to this side of the river so that he could really focus more on helping small businesses. The reality is many of the clients that C3 Workplace has, we are professional business-to-business organizations, very often professional services. And Eugene and I were talking about, you know, the great asset is your brand, and how do you protect that? As an organization, C3 Workplace, we opened under one brand, and we spent a lot of time and effort rebranding to this new brand. So I, too, am really interested in hearing about how I can protect that and ultimately perhaps monetize that. And who knows, maybe someday I can sell it and ride off into the sunset. So also in the spirit of housekeeping, we have a, hang on, let me just get to the PowerPoint. Disclaimer up on your screen. Eugene, why don't you tell us a little bit about yourself and your practice, and just explain the disclaimer.
Sure. Well, first, thank you for having me. I certainly enjoy being here, and hopefully this will be at least informative, maybe entertaining, but we'll see.
Well, we'll try.
We'll try. I'll try. I'll do my best. But my background really is, as Donna mentioned, as a attorney. I was in New York for quite some time, almost exclusively as a commercial litigator for some time, and I felt that as I was advising clients, there was a great need for general business advice, and I was always very excited and fortunate to have people come to me and ask me for that kind of advice, and I also felt that there was a need for helping some of my friends and other connections in New Jersey, where I've always been admitted, but I never had a chance to practice as much as I wanted to, except on the litigation. So,
and you live here.
And I live here.
You're a Jersey boy.
I'm a Jersey boy for 39 years. So I actually, by Donna mentioned you have an office in Sparta. I grew up in Sparta. I went to high school there. So I'm very happy to be in New Jersey. I'm very happy to, well, I've always been in New Jersey, but I'm very happy to be having my business here now and being able to help people. So as I mentioned briefly, I'm a commercial litigator by training, but I've also and always advised businesses on all manner of concerns from employment, intellectual property, and general business advice. So that is, in short, what I do.
Excellent. And to toot your horn for you a little bit, Eugene has many, many accolades, and you can check out his full bio on his website. But he has been named by Super Lawyer magazine as a Metro Rising Star, especially in the area 2014 for intellectual property. So we're really lucky and pleased to have you here, Eugene. So talk about this little lawyery kind of disclaimer, and then we can get to the fun stuff.
I'll keep it short because the disclaimer says it all, but for purposes of this presentation, it's for your educational use, and even shorter, I am not your attorney, but if you have any specific questions, we can certainly address that, but this is really for educational and illustrative purposes.
There you go. Okay, so we'll get into the good stuff now. So, intellectual property, hot topic, what is it?
It is a lot of things, but as the slide says briefly, it's essentially a bundle of rights. I don't mean to exaggerate it when I speak with small business owners or entrepreneurs. I don't want to overstate it, but I honestly do believe that it's one of the most important bundle of rights that a small business may have, whether they are selling goods or services. And by that I mean whether there is a concrete good that they're selling, or if they have an intangible asset, then the intellectual property rights are even of a much more greater concern. But the reason I believe they are important is because they are a very key way to brand your business and protect that brand. You, as a small business, whether you're selling goods or you're a service provider, you are trying to create an identity in the mind of your clients and consumers with the product that you're selling or the service that you are offering, so that they, when they hear your name or when they purchase your product or your service, they associate that with a certain type of quality, a reputation, and that in their minds, and you want to keep that in the forefront of their mind. You want to keep your brand. You want to make sure that when they think of the workplace, that's associated with a high quality of service, of goods, of support. That is the importance of a brand, and whether that brand is your company name, whether that's a specific product that you offer, that is very important. Now, that a lot of what I'm talking about really applies to trademarks, which we'll get to in a second. But really, copyright, patents, trade secrets, maybe less so on the rights to publicity, but they all work hand in hand. There is no one element of intellectual property that a business should focus on, because they are layered, and a proper analysis of what rights you need to be mindful of, what you need to protect, will integrate all of the intellectual property rights. Because, for example, you may have a trademark, but you may also have a design. You may have a website. You may have a method of doing business or some proprietary information that's a key to your success, that's non-public and non-obvious. Everything that I've just mentioned spans the rights from trademarks, copyrights, patents, trade secrets, and it's important to protect all of those.
Gotcha. Okay. So should we talk a little bit about trademarks first?
Sure.
Okay.
Trademarks is probably the easiest to communicate, I think, to a small business, because it's fairly obvious with what you're trying to build in your brand. I think people are familiar with brands. It's some, in fact, would say we're hardwired to branding. There are actually some interesting TED Talks on this science behind branding and marketing and advertising. But in short, a trademark itself is something, as the slide makes clear, it's either a word or a design or a logo that distinguishes your product or business or service from another competitor, another business. And it's, for many of the reasons that I stated before, something that's very important to distinguish what you provide in the minds of clients, competitors, vendors, anyone who you want to put that brand before, and it will instantly click in their minds who you are and what you do. And although I mentioned there's a word or design logos that are most frequently used as trademarks, Colors can also be trademarked. The Tiffany blue, the T-Mobile magenta, the UPS brown.
True. The blue box.
When you see that color without anything else around it, you know where that comes from.
Very true.
With the trade dress, but trademarks are very, very important. They don't necessarily have to be registered for you to have a right to a trademark. There are rights you have under each state's common law or case law that's been built up over the years that will protect some of your rights. And the most important part, if anything, if I communicate anything about trademarks, it's really using it in commerce. The right that you have to your brand, to your trademark, is really established from the date of use. And that means even if you've never registered it, if you have a trademark, you'll be using it in commerce for 10 years. Even if you have somebody else that maybe registers something that may be similar to your mark many years later, it will really come down to what party was using that mark first.
Right.
And so it's registration. When I say registration, it's really federal registration that I'm talking about.
Right.
Although many states, in New Jersey, you can register your mark locally. But when I speak of federal registration, I think I'm referring to the registration of the Patent and Trademark Office.
Gotcha. And
that provides a lot of extra benefits. One, to bring a federal lawsuit if you need to for infringement. You have access to certain types of damages, but you also have a presumption of validity that the mark is yours. So there are a lot of benefits for trademark registration.
Well, and so you're saying presumably it's something you want to do when you first start out, but it doesn't necessarily have to be.
Correct. Ideally, and I do advise startups on this frequently, it's often a fairly any expense is substantial in your startup. Depending on the type of business you're in, especially if you're in the technology sector, or if you're really dealing with an intellectual asset, that's the heart and soul of your business. It's very important in the beginning to register and really protect your trademark. But yes, you don't have to. Eventually.
Right. And you talk here about trademark being a word or combination or a sign, which I get the logo. Talk to us a little bit, kind of flipping into copyright. Where does the difference between that combination of words grow into needing a copyright, or talk to us about copyright and how that differs?
Well, copyright it overlaps in some ways with trademarks, but really it covers a creator's right in anything, literary creation, music, and any artistic work. So that's fixed in a tangible medium. And that means it protects your books that you write, any musical compositions, films, photographs.
And we have a lot of professional service providers, coaches, and they may want to, do they copyright their workshop materials? Does that fall under copyright?
Absolutely. Anything that you write down, that you present, that you use, whether it be workshop materials, whether you have anything on your website that you're educating people about, or that's part of your service that you provide, that's very important to copyright, so you don't have anyone essentially misappropriate any of that information and start using it for themselves or passing it off as their own work. Same thing for photographs that appear, and any photograph that you use, or picture or design that you use.
Yeah, we've heard of not good stories, but people use photos they should.
Yes, and in fact, that's one of the more frequent questions I receive. I had a friend that called me once and said, listen, I knew what business he was involved in, and he had a blog, and he said, listen, I got a call about my blog. And I said, so when did Getty Images contact you? And he said, how did you know? I said, well, they police very effectively their works, and so whether you're a personal blogger, it's a little easier nowadays, especially with Getty, but especially if you're using any of these works for commercial purposes, photographs come to mind most I think. Especially in the age that we live in now, with the ease of access to technology on the internet, anyone can take a photograph and put it on their blog. There are restrictions to doing that. I think people, for the most part, are mindful of that, but it's still important to communicate because rights holders can enforce their rights in that way. That is an infringement to take someone else's work and pass it off on your own or use it for purposes that are not authorized by the license.
Right.
So a copyright will protect all of the elements of original expression. But one of the important things about a copyright is that you may have the same idea as somebody else. Or let's say, using Rocky as a good example about the story about a down and out, boxer who gets a big break. That's a nice idea, but the expression of the idea and the creative element is what makes Rocky unique. It doesn't mean someone else can't make a story.
Of course, it has that. Right. Okay. Absolutely. Okay. Now, because we have so many coaches and consultants and business owners that are developing content as a way to monetize their business beyond just the hourly service. I know trademark and a federal trademark is a pretty complex project, and I don't ever recommend that anyone does it without a good attorney. Is copyright a similarly complex project? Because I get a little overwhelmed when I think, boy, if everything I produce here, I have to actually file a copyright. Tell me a little bit about the process.
Sure. And copyright, in the same way as trademarks, you don't need to register anything to have a right in your work. Okay. As soon as you put pen to paper or type anything out or design any work of art, you have a copyright. Federal registration is available, and it's actually fairly simple. In fact, most of my clients who I advise, if they're looking to copyright something, I actually point them in the direction of the Copyright Office. It's pretty easy to do it yourself. But and it's not terribly expensive. I think the rates changed recently, but it's essentially cheaper to do it online, around $35 for a single authored work, maybe $55. If you have to do it in paper, it's a little bit more expensive, but it's pretty easy to do it online. You get many advantages in registering it with the Copyright Office, including being able, again, to bring a federal suit. But you also have a lot more, for example, in copyright infringement action, which again, you'd be able to bring once you register the work. There's statutory damages available, which can often be very significant, and you may see this. And I've heard of it when the music industry was pursuing a lot of downloaders for illicitly downloading and copying their works. The damages available in those cases, there were very famous cases of the music industry going after grandmothers who had a few songs, maybe 6 or so, or downloaded on their computers, and it's basically $150,000 per violation, which is significant, and that's why it's very valuable to have that copyright registration.
Gotcha. Good. So let's move on a bit and talk to us a bit about patents. We certainly do have inventors out there, and I know patents are certainly a tangible asset that can be sold. So talk to us a bit about that.
Sure. Patents, unlike maybe some of trademarks and copyrights, for example, just to get back to copyrights quickly, because we'll segue into patents. When you register a copyright, you do have it for that exclusive use for a certain time. It's a fairly extended time. Trademarks, on the other hand, once you register it, you have it for, as long as you properly maintain that trademark, you have it for essentially a limited period of time. Patents, however, are different, and the reason they're different is because when you register for a patent, you essentially get an exclusive right to keep others from practicing that patent, from copying that invention, and you get generally 20 years exclusive license. And the exchange or the agreement that you make is that you agree to make the invention publicly available, the information about it publicly available, so that after the license expires, it goes into the public domain and others have a chance to freely innovate on that patent. The example that I use here is the mouse chef. It's the design that's generally submitted with the patent, but the one below it, which I don't know if anyone has young kids, but I have 2 young boys who like Legos. And
boy, those Lego stores or something now.
Right, and although the patent, the Lego brick has expired, I do like the design, which is I've used it here. But it goes again to the limited nature of the patent right. Again, if you're in a different technology sector, I think you can, if you're following a patent for a certain drug, for example, I believe the time is much less in terms of the license, usually 5 years. But the patents certainly govern the inventions that people create or inventions, innovations. The utility patents, the design patents, they're in the last categories. If you're creating a plant, a new plant, for example, that's an interesting patent. But most people probably generally use utility design patents.
Okay.
That's their invention or a certain design or a certain method of a business method or a process for making something.
And I have to say the Lego example is probably a great example of trademark and patent because they're so well branded that I don't know or I'm not aware of lots of knockoffs and competitors. I'm sure they're out there, but it doesn't seem to me they're having a great impact.
Right, and you bring up a great point, and this is why I love using Lego for many reasons. Not just because I like them and I did them, but they are a great example of everything you just said. Because one of the things about trademarks, just to harken back is that you have to be vigilant about your trademarks. So, for example, if someone else starts using something that's very similar to your own, and you don't do anything about it, that will negatively impact you if one day down the line you decide to have court action or challenge their trademark, or their use of that mark. Lego is an amazing company because as many people know, if you've ever picked up a Lego brick, on every little nub it says Lego. They have their logo everywhere. They have their brand name everywhere, and they are very, very good about protecting that brand. And making sure it's as both well-known and monetized and protected as possible. Where obviously when they have the patent right, they enforce that as well. And clearly, they, as we all know, if you've ever been into, and anyone's ever been into Toy Story or seen a movie, they license or license many other popular characters, so which themselves are protected by trademarks and copyrights. And so it's a perfect example of a company where there's many, many, many different layers of intellectual property protection.
Yeah, that's great. Kind of moving along in the continuum of intellectual property, talk to us a little bit about trade secrets.
Trade secrets is something that I view as being extremely important, and it's actually one of the topics that I speak with most frequently with business owners because it covers a lot. It basically applies to any proprietary information, again, not obvious, not known outside the business, that is key to giving that business a certain competitive edge. And the examples that I provided on the slide are maybe the most obvious. The recipe for Coca-Cola, for example, something that's never been patented. It's locked away in a safe, and they get a lot of mileage and have gotten a lot of mileage over many, many years talking about how it's so secret and no one knows about it. And same thing with the Kentucky Fried Chicken. The recipe for the spices is similar. Something that maybe some people know, maybe don't. WD-40, the patent, the recipe for the compound was never patented. It's been a trade secret for years, locked in a vault. It provides some powerful protection for because the advantage is that it's unlimited in time, like a patent. So as long as it's not known and it's safeguarded and there are proper procedures and protocols in place internally at the company, so it's known only to a limited number of people. There are confidentiality agreements in place, non-disclosure agreements in place, and they're working with third parties and vendors, and also when there are internal protocols and procedures in place governing employee access to such proprietary information and what can be done with it and how it's safeguarded. As long as all those procedures are in place, the trade secret can be very powerful. It has some drawbacks, but really it may be appropriate, especially where patents may not be available. And it's something that I speak to businesses a lot about because it does cross over into how they both manage their employees, because one of the biggest risks to trade secrets being misappropriated comes internally and from employees that gain access and then leave and maybe go to a competitor. And the downside, or probably the greatest downside to a trade secret, is that generally once it is released into the open, it's no longer a secret, and it can no longer be protected. And so there are criminal and civil penalties for the misappropriation of trade secrets, and the ramifications of releasing a trade secret can be fairly eye-popping. There have been many cases where there have been employees that have left that have gone to a competitor, and where civil criminal charges have been brought, and where the damages are in tens of millions, if not hundreds of millions of dollars. We hear a lot about other countries and third-party actors where cybersecurity issues are really playing out, and businesses are under attack, especially many large businesses, as we hear almost daily from hackers and others who are trying to get into not just employee information, but their own confidential information. So the trade secrets part of it is very important to really any business.
Right, and it sounds to me like many of these intellectual properties overlap as they should, so you have multiple layers of protection. This last one that you have mentioned, I honestly have not heard of. So talk to us about rights of publicity.
Rights of publicity, generally included in the under the intellectual property rubric, is one of my favorites, just because it involves a little bit of celebrity, which is thrown into the mix, but essentially an individual's right to control the commercial use of their name, image, or likeness, and to protect against the misappropriation of that. So the examples that are on the screen, for example, if you have the Elvis Cup, and that may be the most obvious, where you have a celebrity that's trying to monetize their own brand, and their brand is themselves. They're like, much like athletes, and sports stars, which is the reason for the image below. The Nescafe image, I think, is interesting because it relates to what happens when your image is misappropriated and used without your authorization. And you see this very frequently. So here, the image of the man on the Nescafe packaging is there because it was a fairly famous case in the early 2000s where the gentleman in the background, who's a school teacher in California, came across his image when he was a young model on the Nescafe packaging, and this was used many, many, many years earlier when he was young, and all of a sudden he sees his likeness being used for, again, commercial purposes, and he filed a suit in California because of that. Right to publicity is really governed by each state's laws. Some states are more protective, some are less. New Jersey, for example, doesn't have a statute, but it does have a lot of common law protection for to protect an individual's right to protect their likeness. This comes up a lot. Again, I represent models and actors and actresses, and this really does come up somewhat frequently in that industry. But, for example, it's been in the news recently with respect to the NCAA, who has profited a lot from student athletes, and there's a very famous case that was going on concerning the Ed O'Bannon and other NCAA athletes who were having their likenesses used by the NCAA on either video games or for merchandising or for any other commercial purpose, and they were receiving anything from that. So it's an interesting part of the law. I think it's fairly unique, but it clearly won't affect businesses much, but it may affect certain industries more than others.
If some of our business owners become incredibly successful and achieve celebrity phase, with celebrity status, it may be helpful to them.
I should maybe put a little caveat on that. I don't mean to say it doesn't affect every business, but in a way it does, because you have to be mindful of what you use. Exactly. So in that respect, yes, it does affect.
Got it. Now, as usual, the time flies by. Would you believe that was a half hour?
Wow.
I know. Time flies by. So Eugene will also be one of our office hours experts next week, where he will be available through our office hours program for complimentary consults. You can go to our website. There are only 4 slots, and they're going to go fast. March 27th, he will be doing a lunch and learn at IT Radix in Whippany. And on April 16th, he will be doing a breakfast seminar for the Essex County Small Business Administration and something else at McLoon's in West Orange. And, of course, you can visit him at his website. So, Eugene, thank you so much for helping us to understand a little bit more about this topic of intellectual property. And I just wanted to come back to answer one thing, if you can. You talked about some interesting TED Talks. Many people know I'm a huge TED Talk fan, as many people are. Is there one or two that you would recommend that our listeners check out as regards to intellectual property?
Sure. There's actually what I will recommend maybe as a taste of them. There's an interesting podcast that NPR puts out, and I guess in a partnership with TED, but they usually pick a theme, and they have many TED Talks on that theme built, so it groups a lot of them together, so I check that out. I'm sure you can find it on.
Okay, TED Talk, great.
And in particular, there's one that I have been looking at recently, just because I find it interesting. It's one that Mark Ronson does, who is a really famous DJ and producer, but he really talks about sampling in the TED Talk, but it really brings to light questions about what is original, what is originality, at least in music, but it really affects originality. What is original? Because some would argue that really nothing that anyone creates, including businesses, is really original anymore.
It's a remix of.
Yes. So that's a particular favorite.
Excellent. Well, thank you again, and thank you for joining us today. We will wish you a successful afternoon, and we will see you soon at the next event. Thanks so much.
Thank you.
All right.